It's now time for me to launch the first session of our conference, which is the panel entitled Exploring the Interconnections Between Tax Crimes and Corruption in the EU member states and in the United Kingdom. So I'm delighted to give the floor to the chair of the first panel, Professor Nicholas Ryder, who serves as Professor of Financial Crime at the University of West England, Bristol. Dear Nick, the floor is yours.
Great, thank you, Costa, and good afternoon from a very warm Cardiff. I don't know how warm it is across Europe, but it's far too warm here. And being Welsh, of course, I'm not used to the very hot weather. Anyway, thank you, Costa, for the very kind introduction and inviting me to chair the first panel discussion for the two-day conference. I'm very honoured to be asked, and I'm looking forward to hopefully three outstanding presentations from a variety of experts today. So I'll briefly run through the panel with you. First of all, we have Dr. Vasilios Petropoulos, who will be talking about the interrelation between tax crime and corruption, the Greek experience. Then we have Dr. Branislav Hock, who will be talking about the interconnection between tax crimes and corruption in the UK. And finally, we have Dr. Pietro Maria Sabella, who will be given a paper challenging in framing and fighting fiscal corruption in the UK. So each speaker will have roughly about 10 minutes, and I'll try my best to keep everyone to that particular time frame, if that's okay. I will do my best to monitor the question and answers. I will try not to hog the questions myself, because I've got lots of questions written down for every one of the speakers in terms of probing their knowledge. So Dr. Vasilios, the floor is yours. Thank you very much for attending today. Looking forward to your presentation. Thank you.
Thank you very much. Thank you very much. And also from my side, just a moment, I think I'll start sharing my screen. Just a moment to find. Okay. I think that's okay now. So thank you very much, Professor Ryder, and big thanks also to Professor Costantino Grasso for the very good working experience and the general experience in this program, which is something that I think that everybody enjoyed. Tax crime and corruption, the Greek case. Well, in Greece, I think it's like also in most other jurisdictions, the tax criminal law is somehow subsidiary to the administrative one. It means it's regulated in a special criminal law. It's called the Greek Code of Tax Procedure, the CTP. It's a special law. It's constantly amended. It's perhaps sometimes over-regulated. There are all these kinds of experience in the Greek, in this Greek special criminal law that leads in some cases to problems. There is apart from this subsidiary character of the criminal tax law to tax administrative law, there is a resemblance between tax crimes and specific forms of common crimes as described in the special part of the Greek criminal code. For example, the tax evasion in the income tax, it's somehow there's a resemblance with the fraud, non-payment of VAT or other withholding taxes. It's a form of embezzlement. Falsified or fictional invoices, using, accepting, or editing them, issuing them, is also a kind of forgery. Tax crimes are somehow special to these specific forms of common crimes. So this special criminal law that applies only to tax crimes, which are also in their turn subsidiary to the administrative ones. When talking about subsidiary with the administrative tax law, one could speak about the material subsidiary and the procedural subsidiary. The material, it means that the administrative act which imposes the tax is part of the actus reus, so of the actus reus of the criminal tax of the tax crime. And furthermore, a tax crime is often the administrative actus reus plus the exceeding of certain limits. So Greece, I think it's like Austria. We are both countries that follow certain limits. Above a limit, there is a criminalization. Below this limit, it's only perhaps administrative liability. And so in that sense, there is a material subsidiarity to the administrative law. And there's also procedural subsidiarity, and this is also corruption related in some cases, meaning that prosecution of criminal tax offenses takes place only upon notice of the tax authorities. If the tax authorities do not inform somehow the prosecutor, then the prosecutor cannot start the criminal trial, the criminal tax trial. And there's a further normative impact of this subsidiarity, meaning, by saying normative impact, tax evasion can be socially perceived as an offense and can be efficiently combated as such, only if the taxation system itself is socially perceived as just, fair, and necessary. There has been surveys from 2018, but I think nowadays the results would be the same. The Greek society is not changed that much since 2018. That 41% of Greeks said that tax evasion is a form of righteous defense against the unfair Greek taxation system. 37% thought that tax evasion was a result of excessive taxation. 64% of the Greeks would prefer lower taxes, even this would result in less welfare state. On the other side, it was a survey that was published in a German newspaper at that time, the Rheinische Post. 75% of the Germans declared that they would be happily continue paying their taxes if the welfare state remained at these high standards. Now, this means that somehow, since we're both in the European Union, Greeks and Germans, somehow something is perceived otherwise in Greece than Germany. And this is how the tax crimes are also related to corruption. Corruption itself, it's a legal and social phenomenon. If there is no specific crime, a corruption crime, it's a more or less an improper or unlawful transaction or trading of relations, which is characterized by lack of transparency, and which is also aiming at an improper economic interest. So therefore, one could say that in most of the cases, the corruption crimes are bribery crimes, which result in bribery in public and private sector, and interconnecting with tax crimes, they are easier to occur when the tax system is not perceived as just, fair, and necessary. And this is how the aforementioned survey of Dianeosis is also connected in this problem. The interconnection between tax crimes and corruption, it's interconnected through the tax authorities. These are the most vulnerable ones to the corruption practices. Why? Because they are the one who practically form the indictment. They are the one who send the report to the prosecutor, and if they don't send the report to the prosecutor, then the prosecutor cannot start for himself. That's how it's regulated in the Greek law. He cannot start from himself the pressing of charges. They can further calculate the amount that has allegedly been evaded, and this is also something very important because, as I told you, Greek criminal tax law is subsidiary to the administrative one, also in senses of specific boundaries. So if boundary is exceeded, the amount is exceeded, then we have a crime. If not, it's just an administrative penalty. And this is something that's calculated more or less by tax authorities. And the most important thing is that they are part of the executive. It means they're not judicials. They have this hierarchy. They are there's this hierarchy in them under the Ministry of Finance, and they're not independent. How could this be dealt with? There have been several proposals. Some of them have already been implemented, and I think it's in the right direction. First thing is the general digitalization of the whole taxation proceeding. In this view, one could see that there is less physical interconnection with tax authorities. And the second one is the independence of the tax authorities. And this is also something that more or less has been implemented the last years. And this is also something that has been positively seen and has come to positive results. Further to that, what is the further cause? Is it the poor legislation perhaps as an institutional vulnerability? Could one say that poor legislation could also lead to this interconnection of corruption and tax crime? There has been a criminal reform in Greece in 2019, and until that time, it's true that Greek financial crimes were perhaps the most severe, one of the most severe in the world. There was a life penalty for economic crime in some cases, if it was against the Greek state. So it was stated by everybody that a reform was necessary. The thing is that in some cases it changed the character of some bribery crimes, and this resulted from a felony to misdemeanor, and this resulted in time limitation of pending cases. And this caused, this criminal reform caused an ad hoc procedure, according to Rule 34 by Greco against Greece. In fact, well, by the time the report was final, the Greek law was already changed once more, but the Lex Meteor should already apply. The second thing is we haven't already implemented the directive concerning the whistleblower directive concerning the protection of the financial interests of the European Union. This is something that's being delayed, perhaps for the wrong reason. Why I'm saying that? Because it's the testifying under hidden identities seen as against a fair trial, which is something that's against the whole spirit of this directive. There are special prosecution authorities that constantly change their scope, meaning that they form an interconnection between the executive authority, special prosecution authorities, and this is also something that it's regarded as problematic. In some cases, there are
Elliot, you just got about 1 minute to go, if that's okay.
Yes, I'm finishing.
Thank you.
Yes, there have been some clumsy attempts to deal with the nebis in idem dual sanction issues. This resulted in some cases in time limitation, which were further reversed by the Greek Supreme Court, and this is something of course further problematic for the rule of law. There have been several attempts, as I told you, the digitalization of tax services, the extensive use of plastic money, and transparency on tax spending, that should change the whole idea of how people see taxation and react upon that. And there have been some special investigating powers, especially for several prosecutors, regarding corruption crimes. This would also be used in tax cases when there is corruption-related case. So in that case, we say that there is the legal how do you say, point of view. There is the law is there. The thing is the implementation of the law. Thank you very much. I hope I didn't. That wasn't too long. It's more or less some of the results that will be published in a more extensive research of mine. Thank you. I'll just give the floor to the next now. And I'll stop.
That was great. Thank you very much for your very interesting presentation. I think I learned a lot from that, so really appreciate you giving up your time today. So thank you very much for that first presentation. And the second speaker today is somebody you know quite well, Dr. Branislav Hock from the University of Portsmouth. Branislav, it's great to see you again this afternoon. I hope the weather is that good where you currently are behind you in terms of your lovely depiction behind you. So I will hand over to our second speaker, Branislav, who's talk today is the interconnections between tax crimes and corruptions in the UK. Branislav, over to you.
Professor Ryder, thank you so much, and I would like to as well thank Costa Lorenzo for amazing project, and I really learned a lot. It was fantastic. And UK is a great case study of that illustrate how many of the tax-related practices that are actually legal might be considered corrupt, at least from perspective of what we call economic criminology and fiscal corruption. So in this short presentation, I would like to speak and set the context by discussing tax crimes and their harmful effects in the UK. And then I would like to discuss tax crime and link them to economic crime and the agenda of economic criminology. It will help me to justify approach of the report and as well of the VIRTEU project. More specifically, I will discuss, I will use the concept of fiscal corruption as the key perspective that will help me to investigate the interrelation between tax fraud and corruption in the UK. And then I will come up with some findings and perhaps discussion points. So just to say, throughout the conference, today's conference, I'm sure we will discuss in detail various forms of tax crimes and tax frauds. Just to set the scene, we know they are extremely costly. I would, in the UK context, divide it more generally on large transnational schemes involving large organizations and organized crime groups, but as well large volume of relatively simple frauds at the domestic level, which are in huge quantities like false invoicing and manipulation of tax liabilities and so on and so forth. We see quite some data in the UK provided by HMRC, which estimate every year the tax gap, for example, in 2018-19, £31 billion. There's quite some discussion about and critique that HMRC is understating the tax gap, as well other methodologies which are suggesting, for example, tax evasion is around 70 billion and tax avoidance around 11 billion. For example, Tax Research UK is mentioning this. So just to say this complex problem, I approach it kind of from not really strictly legal or criminological perspective. We were trying throughout the programs, throughout the project, to come up with some new ideas. So kind of like to justify that approach, we kind of have a more holistic view of tax fraud and policing of tax fraud, which is based on holistic interdisciplinary perspective. We recently published a book on that, which kind of introduced the agenda of economic criminology. So tax frauds are part of economically motivated crimes and wrongs. It goes, first of all, beyond criminal law. Despite these are called crimes, we don't need to only tackle them through criminal laws. There's a much wider spectrum of wider regulatory context. And moreover, as we will be speaking about this interrelation between corruption and fraud and tax fraud, the focus has been throughout the project and in the report on systemic issues. So going beyond some direct laws. So for example, lack of transparency associated with owners of legal entities and aggressive planning practices. This raised questions of legitimate creation of economic value. Laws can be corrupt. For example, Lorenzo has published quite a bit on this. So, and in order to tackle these complexities, we need more interdisciplinarity, and that agenda of economic criminology is opening the discussion around how lawyers, criminologists, IT specialists can work together to better understand these economically motivated crimes, including tax frauds. More specifically in the project, what we come up with was that we defined for our purposes the notion of fiscal corruption. At least in that report, I define it relatively broadly. And through these lenses, I have been looking at some of these institutional gaps and weaknesses in the UK. So fiscal corruption is an inequality, economic, legal, political inequality in society, allowing for improper tax advantage by bending the rules of the tax system, taking advantage of the technicalities of tax system, or mismatches between two or more tax systems, or deliberately and illegally reducing tax liability. So I'm really, some of these technical legal features of that tax practices are actually in that report considered corrupt. And we can see it's kind of relates, for example, as well to the discussion how UK operates actually, if we count it together with its overseas territories and crown dependencies, according to Financial Secrecy Index, it's the most secretive jurisdiction in the world. You can have a look at some of these rankings. So this taken together in the report about the UK, that report from this perspective provides recommendations. Because it was able to identify some weaknesses, but as well it looks, beyond the way how UK could improve in this space. It's as well kind of identify, and this has been common for all these national virtue projects, some of the symptoms of undue influence and issues of corruption related to political decision making. So in this kind of recommendation section, you will see how to resolve substantive and institutional fragmentation within the UK, how we will see issues with enforcement, international cooperation, and involvement of private sector in policing and interaction between private sector and, for example, its tax-related obligations, for example, for the platforms like Amazon and so on. What I chose for this discussion, just to highlight some of these key findings, and this is my last slide, and I will open for the discussion, was that through that notion of fiscal corruption and economic criminology, we have been able to look at some of these problematic areas. And I'm really just opening discussion as well and giving it for your consideration. There's some snapshot from the actual report where you can clearly see issue of deregulation, exceptionalism, and potential harmful tax practices adopted by national states. So this, you see, there's quite some detail on this. We have been discussing a lot, and what came out of that, issues of revolving door practices. Of course, this has some advantages, but it has some risks too. Continuous reluctance to adopt effective transparency regimes, which has been a huge issue in the UK. Adoption of legal instruments potentially favorable to tax evaders, despite the fact, obviously, we are not going to be selling it in these terms when it comes to the policy, but in effect, they might have they might feature these weaknesses. For example, maybe. I'm not generally so huge critic, but we can argue that the use of deferred prosecution agreements instead of criminal prosecution might be one example of these institutional weaknesses, and practices of limiting the scope of criminalization of tax evasion. This includes some practicalities of policing, for example, trade-off between the effectiveness of policing through the civil route and as compared, for example, through criminal laws, which has been very, very typical for the UK policing authorities. To just conclude, UK has been great. It's a great study that illustrates that many of the tax-related practices that are legal might be actually considered corrupt, at least when once we go beyond some traditional legal definitions of corruption and division between, what is legal, but as well what should be legal. So at least from perspective of economic criminology and that notion of fiscal corruption. Thank you very much.
Thank you, Branislav, for a very interesting presentation, and I'll no doubt ask you about 45 million questions on exchange of information and tax a bit later. Our last speaker today is Dr. Pietro Maria Sabella, and he's going to give us a presentation entitled Challenges in Framing and Fighting Fiscal Corruption in Italy. The floor is yours. Thank you.
Thank you so much. I'm really happy to be here today. And first of all, I want to thank Professor Grasso to be part of this really great project that involved us for a couple of years. And as was said, my studies was on fiscal corruption in Italy in the legislative Italian framework. And what we can say at the end of this path is that even if in the Italian legislative framework, we don't have a formal definition of the concept of fiscal corruption, we have many case law and many literature cases given by the authors in general, also in Italy, that let's understand that there are many interconnections between tax evasion and corruption. But the question is that in Italy, since it is a civil law legislative and juridical framework, the role of the criminal law is the one to respect the rule of law. What does it mean? It means that in our juridical framework, we have different crimes described by the Italian legislator. We have crimes about tax evasion and crimes upon the phenomenon of corruption. So it means that tax evasion and corruption are described separately. From this point of view, it means that, of course, we don't have a juridical definition of fiscal corruption and a juridical instrument used to prevent and to punish this phenomenon as a unique one. But during the research, we had the possibility to understand that if we see how the Italian legislator described corruption and tax evasion, we had the possibility to understand how we have many instruments that represent and that gave us the possibility to understand how these two phenomena are interconnected, and that in reality, the Italian legislator in some way is already fighting against this kind of phenomenon. For example, if we want to make an example of what is fiscal corruption, we can think about tax crimes that can be instrumental to commit bribery. For example, taxpayers that create a black budget aimed at bribing public officials in order, for example, to win public procurements. So in front of this kind of phenomenon, we try to understand if we can really fight against this kind of phenomenon, as said. And the answer was yes. Why? We have, thanks to some regulation given in those last years, many preventive instruments that give us the possibility to prevent both tax evasion crimes and corruptive crimes. As I said, tax evasion is differently described by the Italian legislator, and corruption is described apart. It's just to give an idea of how it is provided by the Italian legislator. We have a criminal law about tax evasion. The most important one is the legislative decree 74 of 2000 that punish many kinds of tax evasion. I will not say all because there are really many. And this kind of legislative decree is aimed at punish fundamentally individuals that commit tax evasion. On the other hand, since 2019, with the law 157 on 2019, we had also the possibility to punish tax evasion crimes committed by legal entities. So we have punishment penalties both for individuals and legal persons. At the same time, on tax evasion, about tax evasion, we have also some legislative decrees of 1997 and 2003 that punish also administrative tax offenses. So we have a double track sanctioning system on tax evasion in Italy. Corruption, the crimes of corruption that are described by the Italian legislator fundamentally at Articles 318 and 319 of Criminal Code. Briefly, I say that corruption is regulated to be punished both if it is committed by individuals and legal entities. In this way, we have many laws that give us the possibility to punish corruption and tax evasion. But as I said before, is from the point of view of the prevention that we have some juridical instruments that give us the possibility to understand how these two phenomena is linked. And I will just give you the example of the model of the tax cooperative compliance that has been introduced in Italy in 2015, thanks to the recommendation given by the OECD. And this kind of tax cooperative compliance that nowadays is open only to large multinationals, gave the possibility to this kind of multinational to adopt the so-called tax control framework. What it is a system that through which the tax authorities dialogue with the multinational in order to understand if the tax regime elaborated by the companies are compliant with the law. Before the punishment can given to the companies, the tax authority see what the company has done and can say, okay, you are compliant or you are not compliant. In this way, Italian tax authority can understand if, for example, black budget are done or not done for other kind of economic crimes. Thanks to the law 157 on 2019, also tax crimes, as I said, have been introduced in the criminal corporate liability. So it means that the tax control framework that is usually used to prevent tax offenses, administrative tax offenses, nowadays has to be in some way adopted also to prevent the crimes, the tax evasion crimes by the companies. The legislative decree 231 of 2001 in fact asked to the companies to adopt compliance programs to prevent all kinds of crimes are inserted in the system of this legislative degree, and companies have to make an assessment, a map of the risk they can have in their activities, and in this sense they have also to see if they can commit tax evasion crimes. And through the dialogue that large companies can have with tax authorities, they also can structure a compliance program that can be also compliant with the criminal law. So in this way, if we are giving the possibility to the companies to prevent tax offenses in the administrative law and tax offenses in criminal law, in this way we should avoid how to say, the commitment of tax evasion aimed at corruption. Another element on which Italian legislator is really focusing is the whistleblower system, the whistleblowing system. Whistleblowing has been adopted in Italy in 2012 in the field of corruption in order to prevent corruption, and in 2017 was also adopted in all the private sectors. So we have whistleblowing system both in public and private sector, and the Italian legislator gave many protection to whistleblowers, even if they have to be implemented. And this is, in our research, we saw that this is a really good instrument to prevent the logic of fiscal corruption, since the whistleblower can call the, can ask to the ANAC, that is the corruption independent authority, to see and to put a light on this kind of bad behaviors adopted in the public administration, but also from 2017, also in the private sector. So we have whistleblowing system that it is a good model to prevent fiscal corruption, the tax cooperative compliance that I shortly described, but you can see more in the report given by Professor Gullo, that was the leading expert for Italy. And we have a third element, and I will briefly describe it, that is the so-called extended confiscation. I would need really much time to describe it, but confiscation is a patrimonial measure adopted in Italy to deprive the convicted person of the illicit profit gained. The extended confiscation was introduced in tax evasion crimes in 2019, and now we have the special kind of confiscation that say fundamentally that the convicted person, the tax offender, can be deprived of all the assets or money and the other utilities whose origins is unable to justify having their ownership or their availability for a value that is disproportionate to his income or occupation. What does it mean? That if a tax evasion crime is committed and the tax offender is deprived by all his assets that he cannot justify, for sure, even if there are many critical issues about this kind of confiscation in Italy, for sure, this kind of measure can give the possibility to the state to deprive the tax offender of those kind of assets that in the future potentially can be used also to commit other economic crimes, such corruption or money laundering.
Pietro, you've got 1 minute left. Sorry, if that's okay.
Yes.
Thank you.
Yes. So these three elements was the measure that, in our opinion, can be the most important to be focused on to understand how fiscal corruption can be prevented and punished in Italy. What we can say for the future, and what is the future challenge is about the alignment of the two proceedings, the tax proceeding and the criminal proceeding. By now, we don't have many kind of norms that let these two proceedings talk each other. So we think that in the future, this dialogue between these two kind of proceeding is fundamental to understand how the evidence in the trial can be used to understand if the offender committed tax evasion crimes or also other kinds of crimes, such as corruption. Thank you so much. I hope to have been clear in my presentation. Thank you.
Great, thank you very much for your fascinating and very interesting. We've just got a quick hand up from Dr. Donato Vossa. Dr. Vossa, did you want to give your question quickly?
Thank you very much, Professor Ryder. Congratulations for your wonderful presentations. I have just a couple of questions for all the speakers. I'm interested to know more about the phenomenon. First, what was the main challenge for the contributors, so for all of you, during your research, identifying a definition of tax corruption, and how could this definition help tailor the solution of national law enforcement authorities in this area? And another point, does the definition of tax-related corruption have its independent relevance, in your opinion? And what is the current scale of this phenomenon in your country? Are there tools, for example, perception index, statistics, and so on, to measure the significance of this specific phenomenon? Thank you very much.
Thank you for the question. Gentlemen, if we can keep your answers to maybe 30, 40 seconds, because I want to get to one of the questions in the Q&A. We've got Stephen Holden. Or Vasilios, did you want to take perhaps one part of that question?
Yes, thank you very much. It's just that to the first question, I think that tax corruption is more corruption than tax crime. It's more corruption related than tax crime. And in that sense, yes, it has to do with the independence, perhaps, of the administrative of the administrative section itself. If they, or when they learn somehow to think more like the judicial sector, then I think the administrative, the tax administrative, then I think this will be not become judicials, but think like them. I think this will be much better. And as I said, I think it's more a corruption thing than a tax crime thing.
Thank you, Donato. Thank you, Dr. Bosa. Well, there are like so many topics that can be discussed. I think one I choose is that notion of fiscal corruption. I think the first intuition was to kind of think about laws and regulations, and the challenge was to detach yourself from this underlying legislative frameworks. So it's the first challenge. Second challenge is that there are quite some established definitions of corruption. So the pressure is that people will imagine something under that term immediately, and perhaps you don't want to follow the same pattern. So it was as well a challenge. And that definition of fiscal corruption I introduced, I think it's more kind of, you should think about it as de lege ferenda, or for the future of the law, as a policy concept that might help you to identify some vulnerabilities and perhaps suggest some solutions. So it's a policy content, how that something is legal, or maybe unfair, but should be perhaps illegal and transfer back into the legal system. Yeah, so this is my first reaction. There are many other points that could be discussed. Thank you.
Thank you, Bronislaw. Pietro, your thoughts on the question, please?
Yes, thank you, Donato, for the question. As I tried to say, we didn't find a definition of fiscal corruption or tax corruption, so we had to move on two parallel ways about tax evasion and on corruption. Even though we saw that we have in Italy a few case law related to the phenomenon of fiscal corruption. I mean, cases in which people have been condemned to have created some black funds to make many kinds of economic crimes, and in these kind of crimes also corruption was in it. So I can say that maybe the logic of the Italian legislator is the one to fight the economic crimes in general. Indeed, I think that tax evasion can be also related to money laundering and also to corruption. As I think you know, in the recent past, we had other case law that through which, for example, offender have been condemned for other related crimes to tax evasion, such self-money laundering, in the period when in Italy there wasn't the direct criminal liability of a legal person for tax evasion. So in a such way, I can say really briefly that we are just trying to listening to this kind of phenomenon and to manage it, but we don't have an instrument, a juridical instrument, just to fight against it. About the statistics, we have statistics on tax evasion. The last communication given by the minister talks about 80 billion of euros evaded in Italy the last year. And also we have statistics on corruption, but not yet statistics that are talking of this phenomenon as an interconnected one. I think because the authorities that control, monitor, and punish the two phenomenon are different. So we have the Agenzia delle Entrate for tax evasion and ANAC for corruption. And the challenge for the future is the one to let them talk more. I don't know if I answered to your question.
That's great, thank you. I'm just going to take a question in the chat from earlier. The question is, gentlemen, can you develop about the role and status quo of exchange of financial information, especially AEOI, between national tax authorities and financial institutions, given the OECD efforts and how DLT could be a solution or not to increase efficiency of CRS XML schemes? So I'll try and get back to Stephen. We've then got one question. So gentlemen, very briefly, if you've got any thoughts on exchange of information.
Yeah, thank you. That's where economic criminology will call for specialists in tech. But I think just shortly, as I understand this, I'm not really a huge expert in that, but I just had a look at National Cybersecurity Center report on this. So you might have a look in there, and interestingly says you use this. When is it appropriate to use it? As compared to, I mean, distribution ledger technology here, as compared to conventional technology. And it's usually when you don't trust, and it's when you don't have trusted central authority that could do that. So I found that interesting.
And thank you, Branislav, for the answer. I'm very conscious. I got two more questions very quickly. Stephen, do you want to make your point very quickly, please, if you don't mind? Thank you.
Yeah, absolutely. Thank you. I think now that the United Kingdom has left the European Union, and therefore we're able to kind of diverge from the wider aspects of the European compliance and regulatory oversight framework, do the panel consider that there may be any enhanced risks to the UK becoming a shelter territory on the doorstep of the European Union, or, for instance, issues with sharing information by leaving regulatory frameworks where realistically the only people or the only entities this is going to benefit are tax criminals or people engaging in corruption?
Stephen, great, thank you for the question. Vasilios, can I give that question to you? I'll give the last question to Pietro then in the chat.
Yes, well, in fact, it's not only about tax crime. That's a general question, perhaps. It doesn't only have to do with tax and corruption. Well, I think that somehow, even if one could say that there has been a Brexit, somehow I think that the way must be found to continue applying all European and British, perhaps, institution somehow in common groups, common investigating groups, in a common way. So in that sense, one could say that there might have been a Brexit, a political one, but a legal one, I'm not that sure if it's going to occur 100%. So this is perhaps a general answer, a more general answer to this specific question.
Thank you. And the last question, I think, is quite timely for Pietro. The question in the chat is, very intrigued from a person in the chat, was wondering if, Pietro, you had any knowledge of lifestyle offences under the UK Proceeds of Crime Act or unexplained wealth orders had been similar mechanisms existed in Italy?
I am sorry, but since my focus was on Italy, I can say that I don't have specific information about this kind of confiscation in UK. What I can say is it is a really peculiar Italian instrument. Why? Because we started to adopt this kind of confiscation to fight against organized crime, specifically mafia. And so we had the necessity to deprive mafious people of all the economic sources. And it's really short what I can say. This provoked many critical issues in Italy. We had many case law in front of the Court Constitutional, but in general, this kind of confiscation started to spread in all the system and adopt to defeat different kind of economic crime. So I think that something similar could be in UK regime, but it's really hard that there would be really something equal to the Italian one for that reason. That is a political and cultural reason that was the one to fight against mafia.
Great, and hopefully, sorry we're a little bit late on that, Costa, but I'd like to thank our three excellent speakers, Vasilios, Branislav, and Pietro. Thank you for a really interesting hour's insight into tax evasion and corruption in Greece, Italy, and the UK. Costa, I'll leave it over to you. Thank you.
Thank you, Nick, for brilliantly moderating this panel, and thank you, Branislav, Pietro, and Vasilis for the interesting presentation. So we will now